Welcome to HIPAA Employee Training.
It is imperative for all employees to receive continual HIPAA training, once during new hire orientation and again on a regular basis to account for any changes to company policy or the law. This is to remind everybody of their responsibility for the confidentiality and security of information reviewed within the organization. At the end of this training, you must also complete and sign an acknowledgement of training and the information that was covered in this presentation. This presentation will cover HIPAA and its applicability to us as members of the workforce. We will delve deeper into the HIPAA privacy and security rules, paying special attention to the security safeguards. Next, we will cover HIPAA violations and breaches. Then we will go through real-life examples of HIPAA violations and conclude with useful tips for complying with HIPAA. Let's go over a brief overview of HIPAA. HIPAA stands for the Health Insurance Portability and Accountability Act. It has since been amended in 2009 by the HITECH Act and again in 2013 to further protect medical information in electronic format. It also increases penalty amounts and spreads the responsibility of compliance to business associates and their subcontractors who handle medical information on behalf of covered entities. One of the most important things to know about HIPAA before moving forward is the definition of PHI. PHI stands for Protected Health Information, and it is any individually identifiable information created or received by a covered entity that can reasonably identify the individual and also relates to the past, present, or future physical or mental health or condition of an individual, regardless of the media form that it is or was stored. We will be referring to this acronym often throughout this presentation. There are two main areas of focus for HIPAA as it relates to most of our job duties here at the organization. These main areas of focus are privacy and security. Privacy is the usage and disclosure of protected health information, whereas security deals with the protection, confidentiality, and storage of protected health information. How does HIPAA apply to our organization? Ask yourself through these next few slides if the organization can be categorized in any of the following, either as a covered entity, a business associate, or a subcontractor. A covered entity is defined under HIPAA as either a health plan, a healthcare clearinghouse, or a healthcare provider who transmits any health information in electronic form in connection with a transaction covered by HIPAA. Examples of healthcare providers would be but are not limited to doctors, medical clinics, psychologists, dentists, chiropractors, nursing homes, or pharmacies if they transmit information in electronic form. A business associate is defined under HIPAA as a person who is not a member of the covered entity's workforce and arranges, creates, receives, maintains, or transmits PHI, or provides legal, actuarial, accounting, consulting, data, aggregation, management, administration, accreditation, or financial services to or for such covered entity, and where the services involve the disclosure of PHI. A common arrangement is one where law firms are categorized as business associates under HIPAA because they transmit, disclose, receive, or maintain PHI in the course of representing a covered entity or a business associate. For example, a law firm may use PHI when creating and executing medical authorizations or subpoenas to obtain medical records. Also, a law firm may use PHI when they transmit medical records to an expert witness. Another arrangement where insurance companies would be considered business associates would be in medical malpractice cases, because this is where the workforce would transmit, disclose, receive, or maintain protected health information in the course of representing a covered entity or another business associate as their insured. For example, a claims adjuster would come into contact with PHI if they were getting medical records to evaluate a certain case. What is a subcontractor? A subcontractor is defined under HIPAA as one that creates, receives, maintains, or transmits protected health information on behalf of the business associate. Subcontractors are also defined as business associates under HIPAA. Examples of a subcontractor would be support services. Support services are those that assist the business associate in maintaining, transmitting, disposing, or storing protected health information. Examples would be a records retrieval company, a court reporting company, a record disposal company, a copy machine vendor, or an IT department that is outsourced outside of a company. The company as a whole is a subcontractor. As a subcontractor, the organization is subject to HIPAA and is obligated by law to have all data treated as confidential and only used for business purposes. As a member of the workforce, we are obligated to comply with the organization's privacy and security policies and procedures. Why comply with HIPAA? HIPAA is the law, and in complying with HIPAA, we show our commitment to protecting privacy and our reputation. We also do so to build trust between our company and our clientele. In dealing with protected health information, we are handling one of the most private pieces of individuals' information. Our clients place their trust in us to preserve the privacy of individuals' sensitive and private information. If you choose not to comply with HIPAA, you can subject yourself to company sanctions, legal penalties, risk to your financial future and/or your reputation. There may be other laws in addition to HIPAA that the organization must follow. For example, there may be state laws that have guidelines on medical privacy that are stricter than HIPAA. There may also be state laws that instruct on maintaining the privacy of other types of personal information not covered by HIPAA, such as driver's license information. Like HIPAA, state laws may impose penalties for failing to follow their laws and are written for the punishments to apply on top of any penalties that HIPAA levies upon the violator. Now on to HIPAA privacy and security. Let's revisit PHI here. Here are the nuances to note. PHI is information created or received by a covered entity. This means that if it did not come from or go to a covered entity, it is not PHI. Also, PHI in any form must be protected. This means electronic data, hard copies of medical records, or medical information spoken by a covered entity's personnel is protected health information as well. On to the HIPAA privacy rule. HIPAA spells out in its privacy rule the ways PHI may be used or disclosed, and it is interpreted that any use that surpasses the privacy rule violates HIPAA. PHI may be used or disclosed to individuals who provide a signed authorization, thereby consenting to the release of their PHI. PHI may also be used or disclosed as required by law. An attorney or court clerk may issue a subpoena, or a court may order that PHI be used or disclosed. PHI may also be used or disclosed if it is subject to incidental use or disclosure, meaning that if your job duties do require you to use or disclose PHI, it may be allowed under HIPAA. Lastly, PHI may be used or disclosed if the Department of Health and Human Services is conducting an investigation and is requiring access to PHI. One of the methods of lawful disclosure of PHI would be through an authorization. An authorization is a document that gives permission to disclose an individual's protected health information, or PHI. You may have encountered an authorization yourself whenever the doctor's office required you to sign a document when you wanted a copy of your own medical records. Now, authorizations are more detailed than ordinary consent. HIPAA requires that an authorization include the following, and mind you, this is not a complete list of everything that is required. An authorization is supposed to include the patient's name, a description of the PHI in a specific and meaningful fashion, the purpose of the disclosure of the PHI, who the intended recipients are, an expiration date of the permission to disclose this PHI, as well as the person authorized to make the use or disclosure of this PHI. One quick way to determine if the authorization is valid or not is to see if the authorization has a valid signature. The signature must be that of the authorizing person or their guardian or their power of attorney. The HIPAA security rule intends to ensure that security safeguards are adopted to protect PHI which may be at risk. These safeguards are further categorized as administrative, technical, and physical safeguards. When adopting safeguards, it is done on a reasonable and appropriate standard. To explain, do we need to follow the highest standard or need the most expensive security that is out there? Not necessarily. Entities of different sizes are required to follow HIPAA, and the reasonable and appropriate standard allows every entity to adopt safeguards that make sense for them given their size and the complexity of their operations. Here is a list of HIPAA administrative safeguards. Under HIPAA, it is required for a company to conduct a risk analysis on a regular basis and to have a plan for managing that risk as well as a sanction policy for anybody who violates HIPAA. One administrative safeguard that applies to most of our job duties is the set of company policies and procedures regarding internet and email use. These company policies, for example, instruct you to access only trusted, approved sites, also tells you that your workstation will prevent you from downloading programs without permission. Your policy also tells you to use work emails for work purposes only, and to not open email or attachments if you are suspicious or don't know the sender. Here is a list of HIPAA physical safeguards, which limit physical access to a company's facilities where PHI is to be found, while ensuring that authorized access is still allowed. Examples of physical safeguard that may exist around the organization are listed here. For example, most employees would be assigned a badge that controls his or her areas of access around the building. Also, the organization may have an office that is activated when nobody is occupying the premises. Proper disposal may be facilitated by designated areas in which to put PHI for shredding or other proper disposal methods. And here is a list of HIPAA technical safeguards. Although encryption and decryption is an addressable safeguard and therefore not required of all organizations, it is a highly recommended practice. Though it may not be within the organization's power to prevent the theft of every single electronic device, it is well within their power to encrypt. Password management is a part of maintaining unique user identification, which in turn satisfies one of the HIPAA technical safeguards. In periodically changing your password and making it unavailable to others, you are helping to ensure that you indeed are the one person who is logging in and accessing PHI. And as mentioned in the previous slide, any portable devices used for the job outside of the workplace must have security and encryption. There are 3 entities that enforce HIPAA on a statutory basis. The Office of Civil Rights within the Department of Health and Human Services investigates HIPAA complaints and may also conduct compliance reviews. If possible criminal activity or civil wrongdoing is suspected, the Department of Justice may accept the case and pursue it to the fullest extent of the law. A state's Attorney General may enforce HIPAA violations by pursuing private civil actions. Here are the civil penalties levied by the Department of Justice for HIPAA violations. For violations occurring prior to February 18, 2009, the penalty amount is up to $100 per violation, but up to no more than $25,000 within a calendar year. For violations occurring on or after February 18, 2009, it can range up to $100 per violation to $50,000, but no more than up to $1.5 million within the calendar year. The Department of Justice also levies criminal penalties for HIPAA violations. If you didn't know or were found to have reasonable cause for the violation, you could be fined up to $50,000 and up to 1 year in prison. If you are found to have known of the violation and then lied about it, it's $100,000 fine and 5 years in prison. If you are found to have violated HIPAA for personal gain or for malicious reasons, then the penalty increases up to $250,000 and up to 10 years in prison. HIPAA violations. How do HIPAA violations happen? They can happen by disclosing PHI-related material to the wrong client, or by improper disposal of records, by mailing records to the wrong address, or transposing work order numbers in emails or the company system. This goes to show that HIPAA violations can happen out of mere carelessness. In addition, individuals who maliciously use or disclose PHI will be subject to the following. They can be subject to company sanctions up to and including termination. Such individuals will be held personally liable both civilly and criminally, and all information, including the name of the responsible party, will be provided to the Office of Civil Rights for their investigation and subsequent prosecution. It is important that we report HIPAA violations, real or suspected, within the company so that they can be investigated, managed, and documented, and you can also help prevent the same violation from occurring in the future. Also, immediate reporting of HIPAA violations can help minimize risk and damages of further unauthorized disclosure of PHI. How do you report possible violations or concerns? If you see or think you may be involved in a possible HIPAA violation, report it immediately to your supervisor, manager, or the compliance officer. After consulting with the compliance officer, it may be determined that a breach assessment may need to be filled out, which will require your cooperation. Let's cover HIPAA breaches of unsecured protected health information. HIPAA defines a breach as the acquisition, access, use, or disclosure of protected health information in a manner not permitted by HIPAA, which compromises the security or privacy of the protected health information. What is the difference between a breach and a HIPAA violation? A HIPAA breach must be reported to the Department of Health and Human Services unless the organization can prove that there was a low probability that PHI was compromised. HIPAA violations, on the other hand, happen incidentally, accidentally, or purposely, but the violations that are reported and effectively addressed can and may be stopped before it ripens into a breach. Every step taken to address a HIPAA violation counts. Here are real-life cautionary tales. Envision RX is directed under HIPAA to investigate, notify affected individuals, and report to the Department of Health and Human Services and to the media as a result of the breach. A mailing error occurred where a PDF file that automated the mailing labels and prescription papers got corrupted. As a result, the wrong information went to the wrong parties, where 540 health plan members received letters containing other members' PHI, which included their full name, the date of service, prescription drug information, and the plan paid amount. This serves as a reminder for you to periodically check that the technology you are using is up to date. Datastat Inc. had to report the breach to their respective covered entity, who then provided breach notifications to the Department of Health and Human Services and affected individuals. The business associate also improved their technical safeguards and followed through on their sanction policy on the employee who committed the breach. An employee of Datastat Inc. accidentally misdirected surveys to 487 individuals after failing to follow the company protocol of reprinting materials after a printer paper jam. This incident became a breach under HIPAA because the wrong information containing PHI was sent to the wrong people. This is an easily preventable breach. Please follow any company policy on the handling of electronic devices or appliances that copy, receive, or transmit PHI. William W. Backus Hospital subjected the violating employee to discipline and the workforce to retraining on HIPAA. As a result of the potential breach, the hospital sent notifications to the affected patients. Against hospital policy, an employee took their work home, including files that included PHI. They had patient names, medical record numbers, dates of treatment, diagnoses, and treatment information from August 11, 2014 to May 29, 2015. Another person in the employee's house potentially saw the PHI belonging to 360 individuals during that time period. The takeaway here is to never take records home. Carilion Clinic has fired and disciplined more than a dozen employees after the employees were caught inappropriately accessing the medical records of a patient involved in a high-profile case in the New River Valley. The breach was discovered in August 2015 when Carillion's compliance officers tracked through the record of a high-profile case. They discovered that the record was accessed more times than it should have by people who did not have reason to do so. Throughout the course of your employment, you may encounter information about a high-profile individual or matter. In these instances, you are to access records only to the extent which is necessary to complete your job. Even snooping to satisfy one's own curiosity is a violation of HIPAA. Useful tips. Here are some useful tips for complying with HIPAA. Primarily, review and follow the rules in your employee handbook. It will reiterate many other HIPAA guidelines. Generally access and disclose records or claimant information on only a need-to-know basis. Lock your computer and follow proper login procedures. Do not add software nor change or delete any that the company provided in your workstation. Be on the lookout for any lost, stolen, or compromised electronic devices and report such immediately. Do not store PHI on mobile devices unless authorized and properly safeguarded. Do not release PHI to the media or individuals who offer to pay for the PHI. Doing so would be grounds for disciplinary action. Thank you for completing the 2015 HIPAA employee training. Please report to your immediate supervisor that you have completed this training. You will also be given a quiz on this presentation as well. If you'd like more information or have any questions on this presentation, you may contact the legal department at legal@secondimage.com or legal@keys.com.